So this is about the center-state relationships that we have been started reading. So what happens in this is the Constitution declares India as a union of state and it is indestructible with integral parts and state cannot break away. This is how the Article 1 of Indian Constitution talks about India is a union of states. Okay. And recently there has been India, that is Bharat, which is a union of states. So recently this has also been in news. So what happens in this is the Constitution declares India as an union of state, and like this brings up the federal feature of Indian Constitution into picture and how the states can work together and build up this strong federal unity. So this is how the states cannot break away. So ours is not confederation. Ours is a federation. It is like the states have been integrated into the union and they have been devolved powers from the center. Whereas in confederation, this can be seen in Switzerland. In Switzerland, all these particular states with different sovereign structures, with different political landscape will come together and form a government at the center. Okay, they will push power through the states, through the union, but here the rather union, it's a centripetal and a centrifugal. I hope you understand this physics like centripetal and centrifugal. So India is it's like the power is coming out to the states from the center. So the constitution does not use the word federation. You have to understand it is very important. And Indian polity is a federal principle. So Indian political structure is a cooperative federalism or bargaining federalism or competitive federalism, but in fact it is a federalism. Okay. Then the division of powers. So division of powers are nothing but so the division of powers could be seen in the constitution divides powers between the union and the states. So how are these powers divided? As we have earlier seen that judicial powers are not divided, right? Judicial is an integrated judiciary, but rather whereas legislative, executive, all these financial structures have been divided between the union and the state. It's a carbon copy. It's a carbon copy of the center in the states. So this can be seen in legislative, administrative, financial, and this varies the relationships between this union and the state, different states that work on. So the legislative structure can be seen from the Article 245 to 255. This is very important because especially the center-state relationships is very important for the competitive exams, or if you are trying to understand how the federal structure of India works. So this legislative relationships of Article 245 and 255, they are mentioned in Chapter 1 of Part 9 uh, of Constitution, division of legislative powers between union and the states based on territorial jurisdiction or subjects items for lawmaking. So this is how the legislative features have been divided under Article 245 to 255, where the territorial jurisdiction is based on subjects and items for the lawmaking, and it mentions that legislative divisions has to be made between union and the states. So then next one is there are three lists: union list, state list, and concurrent list. This is also very important. This can help you understand how the powers are invariably divided between the union and states, and the center and states are required to enact and legislate within the sphere of their activity. Why? Because as if there is any matter that's divided in between union, in between state, in between the concurrent list, if it's in a union list, the states cannot make any law that is in the union list. If in the state list, they cannot override this. If it's in the concurrent list, then both can be considered. So this is how they have to limit their activity. It's like center అనగానే center doesn't have a humongous amount of power, but it has to look and abide by the powers that has been provided to it by the constitution and make laws accordingly. Then let us talk about what is a union list. So union list will have certain factors where states have no say in it, just like defense, armed forces, foreign affairs, war and peace, railways, national highways, foreign trade, mineral and oil resources, elections, and income taxes. These all exist in union list. So as they all exist in union list, the states have no right or no importance to talk about it. And the parliament also have exclusive powers to make such laws. Okay. and it can make laws for whole or any part of India. This is how the powerful the parliament is. So when it comes to union list, and let us talk about what is state list. So state list will have matters of local importance like maintaining public order, police, local government, public health, sanitation. So all these things are under state list. That's why the police, the law and order, the health are in the purview of state list. So state is solely responsible for maintaining its law and order, and state has power to make legislator legislation in regards of subjects that are in the state list, and they can also make for a little part of the state, or it can be applied to the whole part of the state. And these things are not applicable outside the state. So if certain states make certain matters on matters related to its particular region, now that cannot be applicable to another state. That is applicable only to that particular state which has made a law. Okay. So then coming to concurrent list. Concurrent list will have matters such as marriage, divorce, property, agricultural land, bankruptcy, stamp duties, contracts. So all these are under concurrent list. And this concurrent list tries to maintain the uniformity of the law. Like it's not compulsory to maintain uniformity, but they would rather make they would rather suggest that you maintain a uniformity, and parliament and state legislatures have concurrent concurrent power in lawmaking and the items included in the list, and state and center can also enact a law on the same subject mentioned in the list, and central law shall prevail over the state law. This point is very important. Whereas if there is a discrepancy between a law that has been made by the center and law that has been made by the state on the same matter, then the law that has been made by the center will only be followed. State law will not be followed, it will be cancelled out. So, in case of state legislation on a subject in concurrent list, it should have an approval from the president. Let's suppose if a state is making matters on any of the subject that belongs to a concurrent list, then it should get the approval of the president, then only that can be applied to that particular state. And residuary powers are with the center. So, these residuary powers are nothing but cyber laws, and this residuary power consists of cyber laws and criminal laws. Now, next one is Article 248. So, Article 248 is nothing but the union government has power to make laws on such residual subjects. Okay, union government has a law to make on cyber laws or any personal laws. So this is applied to the union, to the parliament. And Article 245 stipulates that parliament can make laws for the whole or any part of the territory, and state legislatures can make laws for the whole or the small part of the territory. Article 245 is also very important, and the territorial limits to the laws of the state legislature, and no such limit to the parliamentary laws. So, if a law is made by any state legislature, it is limited to only its territory. But whereas the laws made by the parliament are not limited, they have to be applicable all over the India. This is how Indian federalism is a federal structure but with a unitary bias. Then proclamation of emergency, like there are some special powers of parliament where it asserts its pressure, where it asserts its dominance on the state. So this can be seen in during the proclamation of emergency, where parliament has power to make such laws for whole or little part of the territory, and any matters are all specified to the three lists. And parliament can make laws on any matter on the state list for implementing the international treaties or agricultural agreements or the conventions. United Nations Privileges and Immunities Act 1947, Geneva Convention Act 1960, and Hijacking Act 1982 are all such part of this thing. So, in case of emergency, the central list only shall prevail, and Parliament also will have power to make any of the changes that are in the state list. So, this is how the emergency powers are. Some of the features where India says that it's a unitary in nature, and Article 249 talks about the Constitution of Parliament can make laws on any subject. So The parliament has can make laws on any subject if the Rajya Sabha declares that subject to be a subject of national importance. Then Article 249 talks about what Parliament can make on any subject if there is no emergency. If Rajya Sabha has declared, if Rajya Sabha passes a resolution saying that that subject is of importance and it is of national importance, and the Parliament can make laws regarding that subject of state importance, then that can be applicable. Then Parliament can enact any law to constitute the Public Service Commission for the concerned state. Then it is if a resolution to that effect is passed by the legislature of that state. So this is like how Rajya Sabha can proclaim the power and authority to the state, and if it is of recognized as a matter of national importance by Rajya Sabha, then it can be followed out. Then if the resolution it is center and state relationships. We are talking about center and state relationships. Then, if a resolution to that effect is passed by the state, then Article 252 talks about power of amendment and repeal law that rest with the parliament, not with the state. Okay, if an amendment has to be made to the constitution, then the power exists, or if law has to be cancelled out, that power exists with the parliament. States cannot amend the constitution. Okay, this is also very important. And the creation of new All India service on the parliament can also be recommended by the Rajya Sabha. So Rajya Sabha, there are special powers of Rajya Sabha. If you had read it in parliament chapter in any of your semesters, so this is very important where Rajya Sabha is handled with certain special powers other than that of Lok Sabha, where it can create all India service, okay, where it can recommend that any subject of national importance. So this is our special powers of Rajya Sabha. Then union government has supremacy over subjects included in the concurrent list. So if the union government will always have a supremacy in the matters of concurrent list, and it will also have supremacy in the matters of state list if it is said so by the Rajya Sabha. Yeah, so that's how you can see the unitary features of the government of India, although it's a federation. Then, if a state law on any subject has president as asset, it should prevail in the state. We have already read it. Like if any law that has to be made by the state, then it should be passed. Okay, so then it should be passed and president should sign it. Then parliament can enact a law adding to amending, varying and repealing any law that has been made by the state legislature. So even the state legislature has made any law in subjects pertaining to the subject list of state list, the parliament can still enact a law adding to, or it can still amend, it can still repeal that law that has been made by the state legislature. So the parliament has power to legislate for the union territories also. Then parliament alone can make extra territorial legislation. Then laws of the parliament are also applicable to Indian citizens and their property in any part of the world. So just so that if you are an Indian citizen and you don't reside in India, but this law is applicable to you and in any part of the world. Okay, if you are residing in any part of the world. Then what is Article 200? See, center and state relationships is very important. Here you have to uh, understand articles. You have to understand the powers of parliament and state legislatures. So then you can like half of your job is done in learning Indian politics. Okay, so I suggest all the students to be very thorough with this chapter of center state relationships, where you can understand what are the powers of state, parliament, UTs, and who can preside, what laws can be prevailed. Okay, so now let us talk about Article 200. Article 200 of the Constitution provides certain types of bills passed by the state legislature may be preserved by the governor for the assent of the president. So, governor has this law authority to preserve any bill that has been passed by the state legislature for to be assented by the president. This is also again important feature. This has been a recent case, you can see it in Tamil Nadu, I think, if I'm not wrong. So please follow up on this case. The questions in future might be on this topic. Then bills on certain matters enumerated in the state list can be introduced by state only with pure action of president. Understood? So if a state list a subject they wanted to assent it or amend it, they should be started with prior approval. President has to approve that subject matters. Then only it can be introduced or debated or passed an act on in the state legislature. Then they have freedom of trade, commerce, and laws relating to properties and essential commodities. Then president can also direct states to reserve any money bills, other financial bills for the state by the state legislature during financial emergency. Article 360. So financial emergency, in case of there's any financial emergency, now president has this power. She can reserve the bills that has been passed by state for, or she can veto it, or she can keep hold on it because there's an emergency, financial emergency going on in the India. Then administrative relationships. Administrative relations are studied in Article 256 to Article 263. So this can be like what it can have all the matters on which Parliament can make laws, which is extended to whole of India. And state can make laws which is in the state list. And this has to be exercised within its territory. So this is how the administrative relations on any law that has been passed by Parliament or the state. Then Article 256 is very important. It talks about state executive power has to be exercised in a way so that it should ensure compliance with the laws made by the parliament. So if a state government is amending or making any laws, so that cannot be like So that cannot be like this. Parliament makes a laws in this direction, state makes a laws in this direction. That is wrong. So both should make at least on a similar note. They should be in compliance. They should be related. They should not be anti. Okay. So this is how it is very important if we are talking about center state relationships. Then Article 257 of 257 Clause 1 talks about the executive power of the state shall be exercised not as to impede or prejudice the exercise of union power of the executive power of the union. This is again similar thing like state cannot over empower or over exercise its power in terms of executive matters which are negative or which are kind of overruling the executive orders that have been made by the parliament. So here what it is saying, it chapter is nothing but although there exists state, although there exists parliament, if there is any law that there's a discrepancy, then parliamentary law should prevail because states are subsidiary to the parliament. Now, next, union government can ask the states to create and maintain the communications in national and of military importance. This is also very important. Then said this is like extent of union executive power over the states. So national highways, waterways, maintenance of that are the duties of the states. Although center will construct the national highways, but it is duties of the state to maintain those. Okay. Then can give directions to the states for the protection of the railways. The railways are also of union matter, but states have to still protect these railways and the proper look into the proper functioning of them. Then, uh, then a law adjudicate on interstate river disputes. So this control over states through all India services, like in interstate water disputes also, this has to be settled in parliament. Sorry, this has to be settled by center. States cannot settle the matters. And All India services also that we have read just before two slides before, it is also controlled by Parliament where Rajya Sabha has authority. Then states can also deploy military, paramilitary forces in a state, even against the wishes of the state. This can also seen in cases where the constitutional or the proper functioning of state has to be ensured. And if the state, if the governor thinks that the state's machinery has been compromised, Then the governor can write a letter to the president saying that the constitutional machinery of the state has been compromised, and you may deploy or you may declare it a president rule or anything, or in order to control the law and order in the states, which could be a threat to the nation, which could be a threat to its citizens. And if they think that the states are incapable of controlling that huge amount of deployment, huge amount of emergency, then the union can deploy its paramilitary and military forces in the state, even the states objects it. Then financial resources are could be studied in Article 268 and 293. This is also again very important. Say this whole unit is very important. This can help you understand how the beautifully the Indian Union with its federal feature has been functioning, and how variably it had control over its states. Then union resources of revenue like exclusive power to levy taxes on subjects of union list, such as income tax, customs, export duties, excess duties on tobacco and jute. Then state resources of revenue can be seen in land revenue, stamp duty, except on documents. So here you can understand that both state and parliament can levy taxes. Okay, then parliament can impose gift tax, wealth tax, and expenditure tax. This is like this is a little bit tricky. This has been news a lot where the GST was just formally introduced, but later on, if you have a basic understanding about how what all tax are levied by the parliament or the union, then that would be a very good go, especially with the competitive exams. And Article 352 talks about all powers are centralized in the union government. And Article 356, its president rule, entire control of the state administrative machinery comes under union. Then president can ensure that all or any functions of the state government can be stalled. Then Article 360, financial emergency, reduction of salaries of the person. So the emergency provisions will make sure that the center will overpower the state's legislative structure. So and also the financial structure through Article 352, 356, and 360. So this you would have read it in an amendments chapter. I don't know, in SEM 2 or SEM 3. I'm not sure. So you can go through the emergency powers again to understand like what all machineries of the state that have been under control. Then special provisions have been provided to some states where Nagaland, Assam, Arunachal, Mizo, and Himachal. Then Article 370 has been revoked. You all know Kashmir. Then centralizing features. Like what is centralizing features? Certain features which ensures that the union has control over the states. So those are centralizing features. So centralizing features is India is in the indestructible union with destructible states. What does the statement mean? This is a very deep statement. So India as an union stays intact. States cannot move away from that union, but rather states can break away from its original existing state, just like how the bifurcation has done in Telangana and Andhra Pradesh with Jharkhand coming into picture, and how this Mizoram, Nagaland, all these states have formed. This also, like Himachal, Uttarakhand, this is like they cannot break away from the union, but they are indestructible. Like today, states cannot be guaranteed that they exist tomorrow. Okay, this feature is very important. Might also be asked as in an MCQ. Then Article 324, it empowers Parliament to change names of the states and form a new state. Yes, and Article 356, Union can impose emergency without the state's permission. Then Article 257 is the executive power of the Union shall extend in giving all such directions. Then Rajya Sabha can also transfer any item in state list to the union list if it thinks it's of national importance. Then unequal representation of states in Rajya Sabha. You all know, right? The representation of members in Rajya Sabha or in Parliament are based on the population. So that Then union government's predominance over all India services. Union government's domination over matters relating to civil, criminal, judiciary. States have no role to remove judges. Then union uniform civil code, property and essential conditions. If there has to be made any changes, they need president assent. Then conflict areas. The appointment of governors, use of electronic media for partisan purposes has to be controlled by the parliament, then deployment of central forces in the state to maintain law and order. This is how centralizing features you can understand all at a place. You can take the screenshot or go through the lectures on YouTube again. Then assigning more powers to the state, demands for state autonomy. Like they wanted financial autonomy, they wanted more administrative powers, they wanted autonomy to cultural and linguistic issues where they can exert their their presence, etc., all that thing. Then there are certain commissions which have worked on for making proper functioning of the center and the state. This can be seen in Administrative Reforms Commission's ARC 1966, first ARC. First ARC is headed by Morarji Desai. So what is this ARC did? ARC has recommended setting up of interstate council. This is also very important. You can write a commission, ARC commission, and what all recommendations it has done, then what all proposals it has made for a proper functioning of center and state relationships. So first, it had called for setting up of interstate council, then appointment of persons with non-partisan attitude as governors, and devolution of maximum powers to the states. This is one of the important feature that has been recommended by the ARC. That is why if you see any governor of the state, they don't belong to that state. They could be a person who have no interest of persona, who have no special agenda, or who haven't worked in that particular state during their prime years. So only the person who has no idea about of that region of that state were made as a governor of that state. Okay, if you cannot become a governor of the state where you have worked in, or where you have been born in, or where you have better relationships, where you know public, where you know like you have settled or resided there. Okay, so the governor should be from other person, should be a person belonging to another state. Okay, so, and also they have asked for a devolution of maximum powers to the state, then transferring more financial resources to the state. Like these resources should not be controlled just in the hands of the center, but if the states have been given autonomy in this financial matters, then they would be accessed and developed betterly. Then another committee is Rajamenar Committee, which has been set up in 1969. So this is like use of Article 356 only in rare cases of complete breakdown of law and order in the state. So this Rajamannar committee spoke about Article 356, where the president rule has been misused by the center, because if they think this can be seen in Kerala, where the non-Congress government was formed and this government was brought down by imposing president rule. So what Rajavanar committee has said that this president rule should not be abused, because if you look at the numbers, the amount of president rule has been variously used in Uttar Pradesh, Kerala, where, and also I think Punjab, where around like 9 or 10 times the president rule has been imposed. So what happens in president rule? The state machinery will stop functioning, and the democratically elected governments would drop down. It would be under the control of the union. Then vesting residuary power of taxation with the states. So this is another recommendation by it. Then Anandapur Sahib resolution also held for, and on based on that 1973 Akali Dal was formed. Then West Bengal Memorandum of 1977. This has also been an MCQ, so they'll ask you arrange it in chronological order. So I think you have to be very smart to understand those. And communist government in Bengal submitted to central government a memorandum of radical demand. This is what the West Bengal memorandum. Then they have also asked for repeal of Article 356, 357, and 360, and equal powers should be allocated for both Rajya Sabha and Lok Sabha. Then next comes very important commission, Sarkaria Commissions. This can also be asked in your semester exams. So Sarkaria Commission was set up in 1983 by Justice R.S. Sarkaria. So what happened was this commission did not suggest any changes in the existing constitutional division of the arrangement, but it had paved a way for cooperative federalism has to be existed between the parliament and the states, where for the smooth functioning of the system would go on. Then Poonchi Commission is also very important, 2007. Again, another important question that could be asked in your semester exam. So it made 273 recommendations in its seven-volume report. This is a humongous report. This is a very beautiful report. If you have time, you can go through. So what all recommendations, major amendments or recommendations that we can talk about is it called for repealing of Article 355, 356 and also put up communal violence bill and set up an National Integration Council and prior consultation of states by center while making any law that are related or that are in the concurrent list and concerned states say in appointment and removal of the governor. So this also gave important notion for the governor's appointment and all such things. So this is all for today, and we have read center state relationships, so you can also understand like how India has a federal structure with a centralizing feature means you can write all the centralizing features of India of that we have understood in the chapter. Then you can also learn about Sarkaria Commission, Poonchi Commission, Rajamannar Commission, Administrative Reforms Commission, all the four commissions, and learn executive powers, legislative powers, and financial powers that have been divided among the states and the union. So if you make a notes of it prior, then it will be very easy for you to write it in an end semester, and also it will be very helpful for you to if you're preparing for any competitive exams, that will be very easy and the revision would go very smoothly. So I hope you all understood the lecture today. And if you got any doubts, you may please go through uh, YouTube classes and do let me know. And so see you all and all the best for your end semester. I hope you'll uh, do better, and it needs much preparation. So please go through that and see you uh, maybe next semester. Yeah. Yeah. So I'm leaving now.